First of all, I want to thank all of you for attending the kickoff event of our second year of the Pitt Family Foundation Speaker Series. For those of you who are with us for the first time, this series is part of the University of Arizona's Participatory Democracy Initiative. The initiative is a partnership between the law school, the School of Government and Public Policy, and the journalism school. And the initiative itself is dedicated to studying the causes of unreasonable partisanship and extremism, and why we have currently such a deeply divided citizenry, and trying to find 21st century solutions to address those issues. Our speaker tonight brings a particularly interesting perspective to that. We also want to educate and develop leaders across disciplines to be prepared to implement these solutions and meet the challenges that lie ahead. If you did join us last year, you know we had a spectacular first year in the speaker series. Ezra Klein, Eddie Glaude Jr., Janet Napolitano, Lawrence Lessig, they all joined us. And this year we're going to have an equally impressive series. Next month, on November 17th, Jill Lepore will join us, and that's going to be followed in the course of the year by Liliana Mason, Thomas Mann, and Jan Werner Mueller, but more on all of them later. Tonight, we have a wonderful scholar, and to introduce him, I want to turn this over to our law school dean, Mark Miller. Dean Miller really conceptualized this program, inspired it, and has helped to implement it. And you can see in the chat where the full state of speakers is for the program. Dean Miller, if you could introduce our speaker.
Great, thanks, Jonathan, and welcome all. We're delighted to open this second season of the Pitt Speaker Series with Professor Jamal Greene, a scholar, author, and public voice whose work goes beyond mere observation and into the territory of valuable insights and, for many of us, instruction. Professor Greene is the Dwight Professor of Law at Columbia Law School, joining its faculty in 2008 after clerking for Supreme Court Justice John Paul Stevens and Second Circuit Judge Guido Calabresi. At Columbia, Professor Greene teaches, among other courses, constitutional law, law of the political process, the First Amendment, citizenship, religion, and identity, and theories of constitutional interpretation. I hope not all of those classes in any one year. He has been a visiting professor of law at Harvard Law School and a visiting scholar at the Knight First Amendment Institute. Before attending law school, he worked as a writer, and he was explaining everything that means for Sports Illustrated, a position that we hope prepared him for the rough and tumble competition of ideas and opinions that we are all witness to today. And since 2020, Professor Greene has played an inside baseball role as a member of Facebook's Oversight Board, a group that adjudicates Facebook's content moderation decisions. A prolific writer, Professor Greene's current book, published earlier this year, explores the challenges of moving away from our hardened political and social opinions. It is entitled How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart. In reviewing the book, my former professor and legal icon, Cass Sunstein, said the book was a provocative argument for more humility and listening and less arrogance and dogmatism. Greene urges that we litigate too much and discuss too little, and that rightism is the problem. Perfectly timed and passionately presented, his argument deserves widespread attention. With thanks to Professor Greene, to Donald Pitt and the Pitt Family Foundation, to Jonathan Rothschild, and to all of you here today, please join me in welcoming and giving your attention to our speaker, Professor Jamal Greene.
Thank you, Dean Miller, and thank you as well to the Pitt Family Foundation and to everyone in the audience. It's really a pleasure and an honor to be speaking to you as part of this series. I want to connect to some of the ideas that motivate the series, which is a series on participatory democracy, by spending some time talking about one of the preconditions of democracy that I think we don't talk about enough, which is which is disagreement, and disagreement that is reasonable, that is profound, that is ineradicable. In particular, I want to talk about how legal decision makers and the American people should think about rights under conditions of radical pluralism, which again goes hand in hand with profound and, I think, ineradicable disagreement. Our world is polarized. Jonathan Rothschild mentioned that as he introduced the series, and there's no secret about that. What I want to persuade you of is that one of the contributors to that polarization is how we talk about rights, and in particular, how judges think about the claims of people who want their rights to be recognized. And there are three features of how we talk about rights that I want to focus on as especially common and I think especially pernicious. One feature is that rights are understood by Americans as basically absolute. They are trumps. This is a big part of why they are such a pervasive part of our political discourse, whether it's free speech or guns or even going without a mask. Once it's recognized that I have a right, I should win. At least that's how we tend to understand rights within American politics, unless there's some really powerful reason why I can't win. What that means is that whether I hold a right or not becomes incredibly important. And I'm going to return to that problem, the problem of rights recognition being an incredibly important resource within our politics. A second thing about rights that we tend to believe, and that our courts certainly reinforce, is that rights are identified and protected by judges rather than by other institutions. And so if a legislature passes a gun control measure, or if the governor institutes a mask mandate, all the rights discussion is on one side of the question, whether it's the right to bear arms or the right not to wear a mask. There's very little discussion of the political decision to protect, for example, rights to personal security or rights to health. Those are rights that we pursue by passing laws, not by going to court. But our rights discourse does not see those legislative interests in rights terms. This has a consequence, namely that the way we tend to talk about rights ends up being judicialized, right? Rights become questions of dry legal interpretation. They're questions about texts and questions about the founders and questions about arcane precedents, rather than questions of justice or questions of moral imperative. Whether the right to bear arms extends to concealed carry, or whether all second trimester abortions may be forbidden, or whether race-based affirmative action is permitted at public universities, should not be questions of what Madison believed. And they're not fairly answered by the constitutional text. If we pretend that they are, that removes non-lawyers from the intensely political conversation around those issues. Relatedly, when rights questions end up being judicialized, they end up being understood as questions that have definitive answers, rather than questions that have answers that are naturally subject to negotiation, naturally subject to compromise, naturally subject to mediation. We understand rights too often as questions that are pre-settled by our constitutional arrangements, rather than thinking about rights as fundamentally political questions that, because they're political questions, should be the subject of politics. A third feature of our rights discourse that I think contributes to its polarizing character is that, and here I'm going to get a little bit provocative, we think about rights as if they are scarce. We think about rights as if they are precious. We recognize implicitly that we can't all have rights to everything, right? Because they're going to conflict with each other, right? And so we conclude that it must therefore be the case that only some of the precious values and commitments we have, but not others, get the privilege of being called rights. And of course, we then fight about those things. Right? And the problem is that the reason we disagree so vehemently about the rights that we have is not because some of us believe in rights and others don't, right? It's not that some of us are just right about the rights that we have and others are wrong. It's not that some of us are angels and others of us are devils. We disagree vehemently about the rights that we have because we're all different from one another, right? We have different commitments. We have different values. We come from different backgrounds. We have different experiences that inform our beliefs. We are diverse, and so are the things that we are committed to. In that kind of pluralistic environment, saying that only some of those values and commitments count, but not others, right, necessarily sets person against person and community against community. So how did we get here? Right, we often talk about our highly individualized, highly judicialized, quasi-absolutist approach to rights, as if this way of thinking is a gift from the founders. Right, we tell something like the following story. Right, we have a Bill of Rights. The Bill of Rights sets out a code of those rights that are particularly in need of protection. And when we get a rights dispute, right, the task of the adjudicator is to figure out, right, which of those precious, scarce, codified rights is engaged. And once those rights are engaged, those rights are protected robustly, right? The reason they're listed there is because they're meant to be taken out of the political process, right? And so any kind of balancing or mediation or negotiation or limitation on rights reintroduces majoritarian politics, and that defeats the purpose of rights, right? That's the story that we often tell about our rights culture. And that may or may not be or represent an attractive vision of rights. I think it's not an attractive vision of rights, and I'll get to that. But in any event, it's wrong to associate that vision of rights with the founders, right? The founders of the United States believed very strongly in rights, right? But they did not believe strongly in judicially enforced individual rights that were absolute or anything close to it. Instead, what the Bill of Rights is trying to protect, what it seeks to protect, are the localized political institutions that are needed in order to work out what people's rights would be, right? The thing that the framers were trying to guard zealously against federal interference was the right to live in a self-governing community, right? That was the key right. And that community, acting through its local legislatures and councils, acting through its juries, which are at the heart of just about every provision of the Bill of Rights, acting through churches, acting through family units, even acting through the militia, right? That local community is what would determine the metes and bounds of individual rights, and indeed would protect those rights from outsiders. Among those outsiders being federal judges, right? Those are part of the target of the Bill of Rights. Those are part of the people they're afraid of. Embedded within the Bill of Rights is a social and primarily majoritarian understanding of rights, not the liberal, quasi-libertarian vision that Americans too reflexively ascribe to the founders today. Now, I don't want to glorify that vision. There are lots of problems with that way of thinking about rights, especially in the 18th and 19th centuries. Most prominently, right, the self-governing communities that were at the heart of the Bill of Rights were exclusive communities. They gave political power only to white men, and indeed only to white men with property. Now, that obviously isn't going to work when we're talking about rights in a pluralistic society. If we're genuinely trying to marry pluralism to a culture of rights, it's not going to do to say we're going to have sort of self-governing exclusive communities. Many of the people whose rights were most in need of protection during the framers' time were not empowered to participate in the self-government that the framers celebrated. And indeed, much of the rest of American legal history has been devoted to reconciling that kind of democratic vision of rights that we rightly associate with the founding with a kind of genuine pluralism. And we're still struggling to marry that pluralism to that democratic vision of rights. We recognize that certain kinds of violations, Jim Crow, so segregation, racial segregation, McCarthyism, right, have to be viewed with the utmost seriousness. And that other kinds of violations, and an ordinary law that regulates wages or working conditions, right, should not be overturned casually by judges, right? So we have these kinds of extremes, but we don't have a good way of dealing with the wide range of rights claims that fall between those extremes. Those kinds of rights claims arose in great numbers in the 1960s and 1970s, and they continue to proliferate, right? These are claims to sexual and reproductive freedom. These are claims to gender equality. These are claims about affirmative action. These are claims that a law disproportionately but unintentionally affects a certain racial group. Claims in the criminal procedure space, like Miranda rights, which we've all heard of, right? Or the right to a government lawyer, or the right not to have exculpatory evidence concealed from a criminal defendant. Free speech claims that aren't just McCarthyism claims, but involve campus life, which might be relevant to your lives today. Free speech claims that involve pornography or obscenity, or that involve provocative activism, like burning your draft card. Right? Government support for religious schools, government exemptions for religious believers, claims asking for more welfare benefits, or asking for access to government benefits like tenure at a public school, asking that your driver's license not be revoked, right? Asking that your gas not be shut off by the public utility. These are all areas where what the government is doing is not as severe as racial segregation, right? Those kinds of claims are not claims made against a pathological government, but they are also very important to people and very easy to state in rights terms, right? So you've got this in the modern world, the kinds of things that people associate with rights don't necessarily mean that the government can't be trusted, or that the government is evil, or the government is pathological. You've got to figure out a way of maintaining a commitment to democratic governance when the government is not pathological, but also committing to rights, right? So we end up fighting about all these things, but we've come to view them in binary terms, right? So conservatives will resort to originalism, or to text, or to history as a strategy for figuring out what are the true constitutional rights that we identify, so that they can exclude rights to abortion or rights to same-sex marriage, and can include rights to commercial speech, or rights to guns, or lately rights to religious exemption from anti-discrimination laws. Liberals and progressives resort to a variety of interpretive theories as a way of getting at what they think are the true constitutional rights. So they can include the ones that the conservatives want to exclude, and exclude the ones that the conservatives want to include. And so in that sense, everyone is a little bit rightsist. We discriminate among the rights we think are important and the ones we think are not important. In this way, polarization around constitutional rights ends up aligning with polarization in our politics over many of the exact same issues. But it does so only indirectly, by translating political debate into a debate over what the framers really thought, or over whether strict scrutiny or intermediate scrutiny applies. These are legal terms of art. Lawyers then come to believe that those kind of abstract legalistic questions about tiers of scrutiny, are what rights conflicts are really about, right? That those abstract legalistic questions get at the relevant facts of a rights dispute. This overly legalistic way of thinking about rights has at least three serious problems. First, it decouples the vital link between rights and justice. And by justice, I don't mean justice in some abstract moral sense. I mean constitutional justice. The Constitution has provisions that are designed to promote justice. Take, for example, a famous school equity case, a case called San Antonio versus Rodriguez. Students in poor neighborhoods in San Antonio got much worse public schools than students in rich neighborhoods. And the reason was because property taxes were used as the basis for funding schools. This is a very common model in the United States. Parents of students in the poorer neighborhood sue, gets to the Supreme Court. Instead of asking, well, why does this inequity exist? What is this property tax regime trying to achieve? What is the magnitude of the burden placed on students in the poor neighborhoods? Is there a way that we can reduce that burden, a way where we can pursue the same interests that the government's trying to pursue without having this inequitable schooling system, instead of asking those kinds of questions, which are questions about justice, right? They're questions that lend themselves to real world facts and speak to the justice of the situation. Instead of asking those kinds of questions, the court instead asked, is there a right to equal public schools? And concluding, the majority here, concluding that any such right would mean that there also must be a right to things like food or a right to equal police funding. The court said that means there must not be a right of that sort. We end up looking at legal categories, positive rights as a legal category. We end up looking at legal categories instead of looking at real world facts. And that ends up distorting the relationship between rights and justice. Indeed, the very justice that rights are meant to promote. Second serious problem. The way of thinking that I've identified here, which I've called rightsist thinking, prevents us from acknowledging that genuine, bona fide, but conflicting rights can coexist and therefore have to be resolved at retail rather than being resolved wholesale. We see this in the abortion rights area, where in Roe versus Wade, Justice Blackmun ends up concluding without any analysis that recognizing fetal rights would have to mean that abortion restrictions are always permitted. The court in Roe versus Wade's failure to recognize that fetal rights might have a constitutional dimension had an immediate impact on the anti-abortion movement. In fact, split the movement in two, with the much more radical camp ending up vanquishing moderates within a couple of years of Roe versus Wade being decided. That split helped make political compromise around abortion nearly impossible because you had much more extreme positions on either side. And so even though intense moral conflicts are exactly what politics, instead of adjudication, is meant to resolve, there is no political middle ground when we talk about abortion rights. There are other ways of doing this, and in the book, there's a chapter devoted to this, a very sensitive, very difficult, very controversial issue, which refers to the German Constitutional Court and the way in which it, in the 1970s up through the 1990s, addresses the same conflict, but from a very different perspective that ends up bringing political parties to the table to actually reach a political solution to this very difficult problem, rather than forcing everyone into their corners where they just kind of root for a justice on their side or a justice on to defeat the justice on the other side. The third problem, and this is a related one, the categorical frame that I've identified means that every dispute ends up being about whether you're in the category of rights holder or the category of non-rights holder. So during this pandemic, it's about whether there's a right to hold a religious service when there's a lockdown or restrictions in place, or whether there's a right not to wear a mask or a right lately not to get vaccinated on the one hand, or on the other hand, whether there's no such right? Only one camp is going to get to win, right? So name your favorite constitutional conflict, whether it's about voting rights or about affirmative action or gun control, a wide variety of conflicts related to freedom of speech, and you see similar dynamics. Our constitutional rights arguments end up recreating our political arguments, but they do so while claiming the certainty of legal interpretation. They do so while studiously avoiding the language of deliberation, the language of negotiation, the language of mediation that characterizes politics in its ideal form. There are ways and resources for dealing with this kind of problem. There are ways of talking about rights that don't require this kind of polarization. In the book, I identify what is in legal circles known as proportionality analysis as a better approach, an approach that focuses much more on the facts of a particular dispute, focuses much more on the relative benefits and burdens involved in a particular rights dispute, rather than essentializing the question of whether one person has a right or someone else has a right. Rights can be understood in very broad terms, so long as we also understand that rights are subject to negotiation, subject to mediation, that judges can play a role, and a very systematic role in forcing politics together, right? Forcing political conversation, setting its boundaries, rather than awarding total victory to one side or another. I'm going to more or less stop there. It will come, I think, as no surprise that I don't think the way we're doing things now is a very healthy way of resolving constitutional rights disputes. And the thought I'm going to leave you with for the moment, before getting to questions, which I very much look forward to, is this. The reason our constitutional rights disputes align with our political disputes, right, is not because judges are activists, right? Many judges may be activists in some way or other, but that's not the reason why our constitutional rights disputes align with our political disputes. The reason our constitutional rights disputes align with our political disputes is because rights disputes are indisputably political disputes. There's no shame in saying that. There's no shame in admitting that. That doesn't mean that judges should not be involved. It does mean that the way in which judges are involved should be a way that leaves space for politics to continue, that leaves space for politics to flourish, that leaves space for people to have leverage within politics in order to engage in negotiation around our rights disputes. Judges have a role to play in setting the bounds for political conversation about rights, rather than trying to decide what our rights are for us, right? That's our job, not theirs. It's we the people, not they the judges. So I'm happy to continue to talk about this or talk about more specific issue areas in the Q&A, but for now I will turn it over to the moderators.
All right, we're back now. Well, thank you for that, Professor Greene. And I know there's a good audience out there, and I know that it's an intellectually powerful audience. So please start to bring in your questions. But I think I'll start with a question. It was really a question I had when I read your book, which is that I think you've identified an issue or a problem in the way that the courts have contributed to this political polarization that we have. But what I'm not, and I think if we could find a model that worked, it could be of great help. How do we get that done? I don't, even though you've given us a framework, how do we get that implemented given, the deep belief in precedent, let's start with, that we have in this country?
So it's a great and obviously very important question. How do you get from here to there? Well, and I'll say step one, write a book and try to get lots of people to read it. But one thing that I'll mention that I think may not come crystal clear through the book is that there are a number of ways in which, and I think people who are deeply embedded within constitutional law often have this objection, right? There are a number of ways in which our legal system already accommodates some of the forms of negotiation and compromise that I'm trying to promote. It's not on the surface, right? So very often it's sort of hidden within more legalistic frameworks, right? So we kind of load the discretion onto the front end of rights disputes, but by which I mean the question of whether you have a right in the first place ends up being informed by how far we think the right should really go, right? So there are already ways in which we limit rights, but without saying that we're limiting rights, and that ends up producing quite a lot of incoherence within the law. And I try to identify some of that in the book. I also have an article called "Rights as Trumps" in the Harvard Law Review from 2018 that talks about some of the incoherence that this produces. So I think as a matter of, I don't know that one needs to necessarily depart from precedents wholesale. What one can do instead is to try to offer ways of giving coherence to the law by identifying the ways in which we are already committed to certain forms of limitation when we talk about about rights, right? So I think there are ways of getting there. Justice Breyer is probably the person on the Supreme Court who's closest to the views that not the substantive views that I hold about individual cases, but methodologically the closest. But even outside the court, and I'll just go back to the idea that, I put out a book that's not just for lawyers, but is also for regular people who are not lawyers, who are not trained in the law, is that we need to just as a matter of public discourse and as a broader community, think differently about what it means to hold a right. Right? I'm pro rights. I believe in rights, but I think that the only way to believe in rights and also to live in a pluralistic society is to understand that rights must be limited by the fact that you live in such a society, and that they must be limited by the fact that there are other people in that society who disagree with us. And we need to collectively, and I don't have all the answers, but we need to collectively figure out ways of managing that fundamental conflict and set of conflicts together, right? And so the book is a call for recognizing disagreement over rights as constitutive, as something that we should expect. And so therefore we need to respond to in ways that manage our pluralism rather than awarding a kind of total victory or essentialized victory to one side or the other.
So we've got a question that really follows up well on the last question, which is, in a broad sense, I think people will agree with you that the way the court is deciding cases adds to polarization. I think, at least maybe with Justice Roberts, there's a recognition that he wants to duck matters because of what could be seen as even more polarization. But the question is, for us to understand this methodology better, can you give us an example of a difficult question where your methodology could be applied so we could have a sense of what a court might, they're going to need to be led to this. How could a court look at this and then apply it? The example that was given in the question, and whether this is a good one or you have another one, somebody comes to the court and says, I have a right not to be vaccinated, whether that's a religious right or a First Amendment right. I'm not, how should a court deal with that when the answer appears to be you either do or you don't? How do you deal with that?
Sure. So I'll say something about that example, but I might give another example first that has actually shown up in the court's case law, and that many of you will be familiar with. And I don't talk about this much in the book, so I'll give you a fresh example, which is Citizens United, which is a case involving free speech rights, right? And Citizens United is the holding of Citizens United is that a law that restricts corporate expenditures on elections violates the First Amendment. Now, why do I pick that example? I pick that example because the way in which the court thought about that problem is to think about the problem of, do corporations have free speech rights? If they do, therefore, Citizens United has to win this case. And if they don't, Citizens United loses the case. And the majority's analysis in Citizens United is not much different from that. And so it's a very polarizing, very controversial decision. If you sort of like corporate rights, you're going to be on one side. And if you don't like corporate rights, you're going to be on another side. But there's another way of thinking about the case, which is one of the things I'm trying to emphasize in the book is rights disputes are about facts, right? They're not about kind of abstract values, right? So what are the facts, the relevant facts of Citizens United? Well, Citizens United was not General Motors. It was an ideological corporation, right? So we might think about ideological corporations differently than we think about other kinds of corporations. Citizens United was trying to put out a full-length movie. They weren't putting out a TV ad, which is what the campaign finance law at issue in that case was mostly thinking about. We might think about a full-length movie differently than it was video on demand too, right? So you only saw the movie if you asked for it, right? So maybe we should think about things differently in that context than in the context of a captive audience or an ad. It's a closely held corporation. It was not a publicly traded corporation. So maybe we think about that differently, right? So there are the law actually said that it didn't say you couldn't, a corporation couldn't spend on elections. It said if it spends on elections, it has to do it through a political action committee that's separate from its general treasury funds. Well, how burdensome is it to set up a political action committee? I don't know. The court doesn't tell us whether that's burdensome or not, right? So you get what I'm getting at here, which is that so many of our disputes can turn on these really important factual distinctions, and we don't need to argue it in terms of whether there's a corporate free speech right or not. We can argue it in terms of the particular facts of this dispute and how far they take us. So when we think about vaccination, I'm perfectly comfortable saying there's a right to not be vaccinated. I think that's not the interesting question. The interesting questions are under what circumstances can that right be limited or interfered with, right? So if there were no public health threat, right? If someone just said, here's a vaccine, we haven't really tested it, and we the government just think it's a good idea to vaccinate you, and you said, no, I've got a right not to be vaccinated, I'll be on your side in that case, because there's no particularly salient interest on the other side. But if we're in the middle of a pandemic, you're talking about a contagious disease, asymptomatic, it's spread, you don't know if you have it or not, it's shutting down the economy, it's killing people in huge numbers. The fact that someone is required to get a vaccine under those circumstances, at least in certain contexts, doesn't mean they don't have a right to not be vaccinated. It just means that there are also other things that are important within society that we value, right? So, and how someone comes out in that kind of conflict is not going to be pre-settled, right? It's going to be settled by argumentation and reasoning and arguments back and forth, right? But that's part of the point, right? Is that's what rights are. It's about exactly those kinds of political conversations and trying to persuade people one way or the other about how the values that we all share, values of public health, values of individual autonomy, values that we all share, what direction do they point in under this set of facts? Let's talk about the facts, right? Let's not talk about whether we have a right or not, because if I'm an anti-vaccine person, the last thing I want to hear is you don't have a right to be vaccinated. That shuts me out of the conversation. I want to bring you into the conversation, but talk about, well, what are my rights as someone who's occupying the same space that you are.
So what I'm hearing you say is that at the highest court level, that court should be much more fact-based than structure-based, principle structure-based. And I wonder what that does to our predictability in the law. And let me give you an example from one of the questions that has just come in. Could you talk about the United States Supreme Court opinions regarding rights of prisoners not to endure physical punishment at the hands of correction officers? Apparently, there's been a recent case where the court really kind of limited the ability to extend prisoners' rights if precedent hasn't already been established. And so the question is, could your approach lead to cases with outrageous fact after outrageous fact and still no liability, civil or criminal, for the behavior? So I guess the question is, in the prisoner's rights setting, if you could, let's play with that in your idea of how facts should drive cases.
Well, so a couple of things on prisoners' rights, and I can say something about predictability as well. So prisoners have a right not to be abused at the hands of the state. They have an Eighth Amendment right. Nothing about what I'm saying is inconsistent with that. What I would say, and here's where the argument of the book comes in, is the question of the rights of prisoners is a question about what the burdens they're experiencing might actually be, right? So if you want to ask, does someone have a right not to be abused? The question is, well, what's actually happening to this person and why? As opposed to saying, no, this is a question that, well, we have to turn to what Madison said, or we have to look at the dry words of the Eighth Amendment to answer this question. No, what we have to look at is, what does it mean to be terrorized in a prison? That's the right that's being sought, right? So those are the legally relevant facts. And I don't know what specific case the questioner was referring to. It sounds like it's a reference to the so-called habeas standard under what's called EDPA, which is the statute that governs when people can bring post-conviction claims to the Supreme Court. And the court has interpreted that very, very narrowly. So I think that's probably what is being referred to. When it comes to predictability, I think that is maybe the most salient objection to what I'm suggesting. I don't value predictability in the same way that the court does. And so if you think that that's an incredibly important value, that might be a perfectly legitimate pushback. What I'd say is the approach that I'm urging is more common outside the United States than that. So the US is the outlier here. And courts around the world, some of them suffer with problems of predictability and legal uncertainty, but many of them don't, right? So Canada, which is just a few hours north of where I am right now, does not have any crisis of unpredictability or uncertainty, but applies an approach that approximates what I'm suggesting in the book. The other thing I'd say is, I started out by saying I don't quite value uncertainty in the way that everyone does, insofar as I think it's okay if in different parts of the country from different courts in different settings, different judges are coming out with different opinions about the same rights, because we just, it's not as if the Constitution is so specific that it really answers these questions for us. I think the Supreme Court has a role to play in harmonizing the law, of course, but until it's harmonized, if there's some dissent around the country, let 1,000 flowers bloom. We think that that's okay when the whole theory of American federalism, right, is that in different places we're going to pursue different policies and reach different conclusions. I'm not really sure why we should value that as a matter of constitutional structure, but not value that as a matter of constitutional rights. We should be humble about our ability to know the right answer, and different courts are going to come up with different answers. And then if it seems intolerable, that's where the court steps in. The Supreme Court steps in to try to resolve it.
Well, so your answer goes somewhat to the next question, but I'm going to put the example with the question, and I'm going to challenge you a little bit. The right to bear arms is a right which need not be absolute. I think that's one that your approach could really be helpful on. How do you believe the political discussions can and should take place that create a reasonably accepted solution by the vast majority of people and politicians? For example, who can bear arms, what type, with what regulations or restrictions, and for what use? And then going to the answer you just gave, can and should those rights be different in Texas than they are, for instance, in California, one state from another? And if that's the case, if we're going to really believe in this federalism as maybe created at the beginning of the country, what happens with our abortion laws? So there's a whole lot packed into there, but
yeah. So two easy issues: guns and abortion laws, right? So on guns, you asked should the law in Texas, should the constitutional law in Texas be different than California? I'm not sure the constitutional law should be different, but gun policy can certainly be different in those two places, which I think suggests there is lots of room for politics to arrive at different conclusions in different places, because we're talking about different populations. Gun control, as with abortion rights, by the way, gun control is an area where if you poll people about what they think the law should be, there's a lot more consensus than there is among legislators, among lobbyists, among judges, even, about what most people believe in a right to bear arms, and most people believe that it can be restricted under certain circumstances. Most people support background checks. Most people think that concealed carry should be limited in certain circumstances, but maybe not in others, right? So there is room for there is a large middle ground here. What our rights culture ends up doing is it ends up, because we think about these rights in somewhat absolute terms, it doesn't give sufficient leverage to the other side, right? So if you are and you look at how courts think about these things, and they're all going to come out the same way. If you're a pro Second Amendment person, there's going to be a case out of New York this term, and the pro-Second Amendment judges are going to say, it's about New York's licensing requirements, are going to say those licensing requirements violate the Second Amendment because there's a right to bear arms and it can't be interfered with. And the progressives in the court are going to say, this is kind of a flimsy right. It's really, and DC versus Heller, which is the 2008 decision on the Second Amendment, saying there's an individual right to bear arms. The other side of that question, the dissent said, no, there is no individual right to bear arms at all. That was the position that the main dissenting opinion took. If that's the position you take, then there's no reason to talk to other people, right? If you're crafting a gun measure and you think the court's going to strike it down, no matter what form it takes, or uphold it no matter what form it takes, then what's the point of negotiating its content? When you give something to each side and say, look, a gun control measure has to give some degree of autonomy to the gun owner, but also that public safety can be a legitimate consideration, and it has to be reasonably well connected to the law. It can't be just so. Again, the details have to be worked out, right? But when you give a little bit of something to each side of a dispute, that encourages political conversation and encourages there to be a politically worked out solution, because nobody wants to go litigate when they're not sure what the outcome's going to be. On abortion rights, I mean, it's sort of too big a topic to get deeply into. But what I will say is that the structure of our abortion politics, and we see this certainly in the Texas law that the court's going to deal with in 4 days from now, is we see states in which the legislature is controlled by Republicans passing extremely draconian abortion measures, and states in which the legislature is controlled by Democrats have very few restrictions at all on abortion. That's not where the American people are, generally speaking. They're very much in the middle of that. Most Americans believe in abortion rights, and most Americans believe that there can be some restrictions on abortion rights. But that doesn't really find much of a home within our politics. That's an indication that there's something broken about the way that we're doing this. If you actually can't arrive, there's just no way of arriving at the political at a political solution that most people support. And I think I think there are a lot of reasons for that. Abortion, the history of abortion politics is very complicated over the last several decades. But one of the contributing factors is that we understand these rights solely in terms of the rights that judges find in the Constitution somewhere, as opposed to thinking about them as rights that require some, again, I'll use the word leverage again, but some leverage that needs to be given to both sides. And that's the story of the German Constitutional Court, actually. So they end up saying, no, there actually are rights to fetal personhood protected by that's a value protected by the German Constitution. Women's autonomy is also a value protected by the German Constitution. And so they force political institutions to try to optimize both of those values simultaneously, which ends up creating a conversation around how do you create genuine choices for people, right? Because if women have genuine choices, that's going to be beneficial in terms of women's autonomy, and also beneficial in terms of fetal life, because if you actually have options, if you have prenatal care, if you have postnatal care, if you have paid family leave, if you have paid employment guarantees, then if you are able to get childcare and so forth, that's going to be, you're going to be more likely to bear the child. And so the political conversation ends up being around what are the nature of those protections, rather than being a kind of a zero-sum scorched earth battle over who gets to control the judiciary.
Well, so yeah, and that's probably a good segue to the next question. Change a little from methodology to structure. The question is, are there some fundamental feasible changes to how the Supreme Court is constituted that you might suggest? Because as you've said, practically the rights that remain or are taken away are those that the court says so. Maybe another way to put that is, what is the relationship between court structure and rights claims? Or particularly in our current rights world, doesn't the claim to structural reforms make more sense, or does that not solve the problem?
Well, I think that our constitutional rights culture is overly judicialized, and I think that goes hand in hand with the court's self-conception as the ultimate guardian of and determiner of our constitutional rights. I think that there are ways in which it's actually important to our democratic system to take the court down a notch. And I actually gave some testimony to the Supreme Court Commission on this question. And I think that means term limits. I think that means a much larger court. I think that means a court sitting in panels. And when I say a larger court, I don't mean partisan court packing. I mean a larger court that is increased in a bipartisan way, because right now the law is too personalized, right? We know who the people on the court are. We associate them with a particular set of values and jurisprudence, and they are kind of the determinants of our constitutional rights. This is and they have life tenure, and they can be selected through purely partisan selection processes, and they choose their own cases, right? This is a profoundly undemocratic way of thinking about who decides important questions. And I think it very much goes hand in hand with this self-conception of we are the ones who speak for the law before all others. Planned Parenthood versus Casey, a case that I generally have more or less good things to say about in the book. One of the really bad things I have to say about it is the way in which the court in that case says it is the job of the Supreme Court to speak of our rights before all others, which is an extremely unhealthy way of thinking about constitutional rights, because the point is, again, it's we the people, right? Not they, the judges, who should be determining the metes and bounds of our constitutional rights, with judges setting some boundaries. I don't think they should be out of the conversation entirely, but they should not dominate the conversation in the way that they do today.
Okay, and as usually happens in these sessions, the questions start slow, and then we don't have enough time for all the questions that are coming in. So let me take two last questions. I think that'll take our time. Let me do it this way. And tell me if this is wrong. This is the question. It seems you're assuming that that the issues that come before the court have pretty clear facts, and that facts should dominate. But so many of the issues that come to the Supreme Court, at least as maybe the court's posturing them now, don't necessarily have clear facts. For instance, in the abortion cases, you might have a set of simple facts, but what the court's hearing is the woman's right on one hand versus those who hold that life begins at conception on the other. How do you make that into a fact question? Or how do you resolve a question like that?
Well, the cases come to the court as cases about facts. Now, that's not always the case. Sometimes laws are challenged entirely on their face, which is a practice that I would generally discourage. But the two most recent abortion rights decisions decided by the Supreme Court were about what are the burdens being placed on women by laws that place certain requirements on the admitting privileges of doctors and requirements for what kinds of emergency procedures are available at abortion clinics. Right? Those are factual questions. Now, if you believe that there is no right to an abortion, you're going to answer those questions in a certain way. And if you believe that the right to abortion is absolute and unquestioned, you're going to answer that in a certain way. But you don't have to commit to one of those views or another in order to say, well, if we're trying to think about the relative burdens here, all we need to agree on is that there is some right to women's autonomy, and that the state is allowed to protect people's health in a certain way. Now let's look at what's going on here. Let's look at what the state's justification is. Let's look at what the actual record is. And the court did that in both those cases, and discovered that, and the district court found, the Supreme Court agreed that these were highly burdensome and had very little upshot in terms of health. Right? That's that's something people are going to disagree about, right? I'm not a utopian. I don't think that there's a way of forcing a kumbaya moment, right? People are going to disagree, but it's a much more productive disagreement to disagree about what is the contribution to women's health of this particular measure, rather than the intractable and irresolvable disagreement that we might have about when life begins. We can't answer constitutional questions by reference to those kinds of questions, because they divide us eternally. And you can't have a system that works for everyone if we're going to be eternally divided on those kinds of questions.
So here's a criticism that I had not thought of, but it's an interesting one. Professor Greene's approach will make for easy confirmation hearings, because the answer to almost every question is, well, it depends on the facts, balancing. It is kind of a good question. Or do you think that that is the right way that it should be depoliticized, those confirmation hearings? What's your feeling about that?
Well, I don't know that, I do think judges have different ideological orientations. I think it's perfectly fine for judges to answer hypothetical questions in confirmation hearings, or answer questions about cases that have been decided in the past, for example, or how would you think about this kind of question? But I don't think we should, whatever one thinks about my book and my set of ideas, I don't think we should measure it by its impact on confirmation hearings, given that the status quo of confirmation hearings is not some kind of idealized search for truth. It's a kind of theater where people give canned responses, and I don't think we get very much out of the hearings as they exist now. I wish there were a way of getting more information out of judges, and part of the way I think one might do that is by not having, if I say I think Roe versus Wade is rightly decided, that does not commit me to any particular answer in a case that comes before me today. That a culture that accepts that as being a reality, which our current culture doesn't, is one where you're never going to get an answer out of a judge. I know I don't know how far we can go in that direction, because the politics of confirmation hearings are such that it's hard to imagine. But that also goes back to my earlier point about reducing the power of individual justices, which I think, if you really want to affect confirmation hearings, you should just give them term limits and increase their size by 3 or 4 times.
So there's 2 more I want to ask. I guess we can do it. One is not as much a question, but maybe we can a comment. This participant says that he or she thinks the court has been taking itself down more than a few notches with the way that it is dealing with some of these political questions. Do you think that there is a way, is it your approach, or will it make it even harder for justices to re-earn the reputation of the court?
Well, I mean, I tend to think that the reputation of the court should be taken down a few notches. I think we should be humble about the ability of courts to answer powerful political questions on our behalf. I think courts should have a much smaller footprint. And so I celebrate the idea that courts are not these kinds of platonic guardians. I think that's an unhealthy idea. But I also think historically, I mean, I guess there are people who have thought of courts in higher regard in previous years, but it's the court has a long history of both being popular and being unpopular, and I don't assume it will stay one way or the other. I think ultimately its popularity depends on the decisions it reaches.
And I think the final question for the evening is that, and we've sort of hedged around it, the idea of inalienable rights, strict scrutiny versus rational relationship, or if you hit strict scrutiny, like you said at the beginning, you have a right. And if it's a rational relationship, it's very hard to get that judicial remedy. That idea of inalienable rights is pretty firmly established in the American mentality. You've got a book. I'm going to hold it up because everybody should obviously purchase it, except you can't see it on my screen. It's called How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart by Jamal Greene. Interestingly, a foreword by our next speaker, Jill Lepore. So you've written the book, but how do we really start a public discussion? How can we make this more of a mainstream conversation about that, something that a lot of us either don't know enough about or hold as a sacred cow approach? How do we start to shift that public thinking?
Well, I think there are ways of communicating with people that are not just in law schools or just in monographs or law review articles, and partly why this book was published through a trade press and is trying to reach a broader audience. But I've also tried I've written a number of op-eds, often around vaccine and masking related issues, that I think do give people an entry point into some of these conversations. And I think when it comes to inalienable rights, right, we do talk about that term, unalienable rights, is a term that we associate with our founding, right? But there are different ways of holding a right, and I guess one way of talking about this is to say, imagine if every right is so the rights, the rights that are talked about in the Declaration of Independence, the life, liberty, and the pursuit of happiness. Imagine if the pursuit of happiness were an unalienable right for everyone. Well, that's chaos, right? And so the founders were not dumb, right? They did not misunderstand that would produce chaos. They thought that political institutions, creating self-governing political institutions, was the way to manage that chaos. They didn't think the way to manage that chaos was to hand our rights questions to judges. That would have been a horrific idea to the framers. They thought the way we resolve these difficult, chaotic, complex clashes of rights is to govern ourselves. And I think we do need to recover some of that, but recover it in ways that are also compatible with living in a pluralistic society, one that the framers did not fully recognize.
Well, Professor Greene, I really appreciate you taking the time with us in Tucson tonight. I know it's 3 hours later where you are. So again, we want to thank you. For those of you who have joined us tonight, I do want you all to mark your calendar for November 17th. We'll be doing this with Jill Lepore. The Magic Bernadette is putting the link for the other speakers in the chat box. But again, Professor Greene, I want to thank you for kicking off our series this year. Your analysis is one that we do need to find a way. We always think of the electeds as the ones who are creating the polarization, and to a great extent, I think they are. But you've kind of brought to our attention that it isn't just the electeds, the judicial system too might need to focus a little on this. So I really appreciate your time, and thank you for being with us, and thank everybody who joined us. So, and good night, and we hope to see you all soon. Thank you.